What counts as an uninhabitable rental unit? Imagine you moved into your apartment 6 months ago. The heat stopped working in January. There's mold growing in the bathroom. And your landlord keeps telling you it's not his problem. Here's what you need to know. That landlord is wrong. And the law is on your side. Welcome to Know the Law. I'm here to break down exactly what counts as an uninhabitable rental unit, what your landlord is legally required to fix, and what you can actually do when they don't. If you're renting right now, this video could save you money, protect your health, and give you real legal power you might not even know you have. Let's start with the foundation of everything. Virtually all U.S. states recognize something called the implied warranty of habitability. That's a legal way of saying your landlord has a legal obligation to keep your home safe and livable. It doesn't matter what your lease says. It doesn't matter if your landlord claims otherwise. This protection exists by law. Here's the part most renters don't know. This warranty cannot be waived. Some leases include language that tries to shift repair responsibilities onto the tenant. Things like, tenant accepts the property as is, or tenant is responsible for all maintenance. Those clauses don't hold up. Any lease term that tries to eliminate your landlord's responsibility for habitability is unenforceable. The law overrides it every single time. The warranty is measured against local housing codes and basic health and safety standards. The test is straightforward. Does this problem make the rental unfit to live in? Not whether it's annoying. Not whether it's inconvenient. Whether it makes the unit genuinely unfit for you to live there. So what exactly does your landlord have to keep up? More than most people realize. Landlords are responsible for maintaining floors, stairs, walls, and roofs in safe and intact condition. A staircase with broken steps isn't just an inconvenience, that's a legal violation. A roof that leaks into your bedroom is the same thing. Common areas matter too. Hallways, stairways, shared spaces, landlords must keep those safe and clean. Landlords are legally required to keep electrical, plumbing, sanitary, heating, ventilating, and air conditioning systems operating safely. Not just installed, actually working, safely. And beyond that, landlords must supply cold and hot water and heat in reasonable amounts at reasonable times. No heat in winter. No running water. No hot water. Those are serious legal violations under the implied warranty of habitability in virtually all states. There's also a federal requirement worth knowing. For properties built before 1978, federal law requires landlords to disclose any known lead-based paint or lead hazards before you sign your lease and provide an EPA informational pamphlet about lead. If your landlord skipped that step, that's a federal law violation. Not every repair issue rises to the level of a habitability violation. The standard is whether the problem makes the unit unfit to live in. A broken dishwasher is frustrating. A broken garbage disposal is annoying. But those issues don't threaten your health or safety in a fundamental way. Compare that to no heat in winter. Sewage backing up into your tub. Electrical wiring that creates a fire hazard. Structural damage that makes a room unsafe to enter. Those cross the line because they affect your basic health and safety. Major habitability violations carry real legal weight. Minor repairs generally do not trigger the same level of legal protection. Repair timeframes vary depending on where you live and how serious the problem is. Generally in most states, emergency repairs, like no heat or no running water, require your landlord to respond within 24 to 48 hours. Some states set more specific timeframes. In some jurisdictions, immediately hazardous conditions must be addressed within 24 hours. Hazardous conditions may allow up to 720 hours. Non-hazardous conditions may allow up to 2,160 hours. Other states require landlords to start and complete repairs for most habitability issues within 336 hours, cutting that down to 48 hours for essential services like heat, running water, or electricity. The clock moves faster when your health or safety is at immediate risk. Your specific rights depend on the laws in your state. Maria rents an apartment in a building constructed in 1972. When she signed her lease, her landlord never mentioned lead paint and never gave her any EPA pamphlet. That's a federal violation right there. 3 months in, her heating system stops working in winter. She calls her landlord. He tells her the lease says she's responsible for appliance maintenance. That lease clause means nothing. The implied warranty of habitability cannot be waived. Heat is a legally required service under virtually all states' landlord-tenant law. Her landlord has an obligation to fix it, and under most state laws, emergency repairs require action within 24 to 48 hours. If her landlord still refuses, Maria may have options including withholding rent, using repair and deduct remedies where available, or pursuing legal action. Under most state laws, repair and deduct rights exist, but the specific limits vary. Maria should document everything in writing and look into her local tenant rights organization for guidance specific to her state. Your landlord cannot rent you an uninhabitable unit and charge you for it. The law says so. Know your rights. Document everything. And take action. Now you know the law. Hit like, subscribe, and share this with someone who needs to hear it. And drop a comment below with the legal situation you want us to break down next. The law affects every part of your life, and you might as well know how it works. Knowledge is the one thing they cannot take from you. See you in the next episode of Know the Law.